at the next meeting, which is proposed for Wednesday, March 22nd at 10 o'clock, but we'll get to that in terms of tying down that time if it's convenient for everybody. And after that, after the committee has looked at the draft report, there would be an examination of the list of amendments to the Act, which would have to be done by the Office of the Parliamentary Counsel. So we are moving apace, as I said, and hopefully we can meet those timelines, but obviously we want to make sure that we do it and do it right, especially with the impact that we expect to get from this. I can't say how important this review is of the Cybercrimes Act, because I'm sure everybody has been seeing what's been taking place in the public space. And the truth of the matter is that our hands are tied, because a lot of what we would like to do, the law doesn't allow for us to do at this point. So again, it's becoming even more and more important as we move along in our day-to-day positions. So
recording in progress.
Today, I would like to just get confirmation of the minutes held on November 20th, for the meeting held on November 24th. I'm not sure if members had a chance to read. I wasn't at the meeting, so obviously I would not be able to move a motion, but Member Gail Rodriguez and Longmore, whoever else from the committee is on, if you could just tell me if you wanted to do it now or you want to take it at the end.
Can we take it at the end here?
Yeah, please. If you could just make sure that you just go through it so that we can just take it at the end for sure. All right. So I think basically at this point, I have seen a response from MOCA in writing, which basically is their original comments to the Joint Select Committee, which was in May 2021. So I understand from the last meeting that there was an issue that came up which required them to be invited back today. I'm seeing here that it was mentioned that the Office of the Director of Public Prosecution support the views of the Attorney General's chambers, that there's a mechanism in the Act that would render data inaccessible or remove data from a computer that was seized. It was pointed out that MOCA had further concerns, and during consultation, the entity noted that it had further comments than the points articulated in the submissions, which I suspect would have been the submissions of May 2021. So I think that's why Mr. Park, is here today. So I think we could take him. I think we could take Mr. Park from MOCA first, and then obviously go into the agenda. So, Mr. Park.
Yes, Chairman.
I turn it over to you, sir.
Thank you very much. Morning, Chairman. Morning, members, colleagues, good morning. So, in our submissions dated May 5, 2021, we made some comments regarding Section 16 of the Act. And having seen the responses from the AG's chambers particularly, we recognize that inadvertently we misrepresented the essence of what we were trying to highlight. We were not asking for a mechanism to be provided to law enforcement by which warrants would be effected. The point we were making is that the provision in Section 16 that speaks to rendering the computer material inaccessible based on the construction of Section 16, 17, and 19 speaks to a temporary state of affairs. For example, the power to seize gives different variations, which allows law enforcement to either make and retain a copy of data, render the data inaccessible or remove it from the computer or take a printout. However, in section 19, there's a requirement on whoever executes the warrant to make a record of the material that is seized, and pursuant to 19.4, there is also a duty to preserve the computer material that has been seized or rendered inaccessible. So in the context that you may, in particular circumstances, be required to reproduce the material, by no means does it mean that it gives law enforcement a power to permanently delete the data. Now, we appreciate the comments made regarding the forfeiture provision, but the forfeiture provision operates in a particular context. The court is designated as the forum that can hear the application, and even though there are permutations which allow you to make the application where there is no conviction, it still requires that the matter be grounded before the court. Now, there are circumstances where, for example, you may conduct an operation, say it's in relation to lottery scamming. You are able to seize devices, and for some reason, and there are very good cogent reasons why you may not be able to mount a prosecution, you then are in possession of property that belongs to somebody. And in the absence of a mechanism where law enforcement can remove offending data from it, it potentially has to be returned to someone who can demonstrate ownership. And I know there are other nuances which may impact that, but that is the core issue where we perceive that there's a lacuna in the provisions which doesn't completely allow for full efficacy. So in the circumstances, we think that if, for example, there could be an explicit statement that in the presence of offending material or data, regardless of the outcome of the matter before the court, or even if the matter is not before the court, once that material meets certain criteria, and of course, in the absence of legitimate possession of that material by whoever professes to be the owner, then there should be some mechanism or authorization to law enforcement for it to be permanently removed from that device, and if appropriate, the device is returned to the subject from whom it was seized. So in a nutshell, that is the essence of the submission we're making to the committee.
Thank you very much, Mr. Park. Members, any comments on that?
Mr. Chairman, let me first apologize. I'm unable to turn on my camera at this time, so I'll speak without the camera if you so permit.
Sure.
I just want to say to Mr. Park that thanks for bringing this to our attention, because I understand the point that he's making, that there is something missing. But I just want to also make the point that neither in 16B2 or 19.4 does it say you have to destroy. So I just want to point out that you don't have to destroy the material. It says render inaccessible or remove. So that's one thing. That's one point. But I understand what you're saying about what do you do with this material when you return, because you're bound to return it to the person. But in some instances, you shouldn't really, because the material is. So I want to just thank you for bringing this, for being so thorough and bringing this to our attention.
You're welcome. You're welcome, member. Thank you.
Thank you, member. Any other members? I know that this was a a matter that both the Attorney General and the Office of the Director of Public Prosecutions was also weighing in on.
Chairman, I don't have a difficulty with the ask. How I understand it is that notwithstanding Mr. Park, you are able to mount a case if the material is offensive in nature, then what you're suggesting is that that material must be removed from
Yes,
the
sir.
device. Because
Yes,
we could have had situations where, yes, you can't mount a case, but the material is of an offensive nature that might even mar the reputation of individuals. And so consequently, what MOCA is suggesting is to remove the material or not to allow it to be accessible for any future. So I'm in agreement with that approach, sir. I have no difficulty with that.
Thank you, Member Gale.
Is there any other member that wants to weigh in on this, or any other of the entities that are on?
Not at this time, Chair.
The Attorney General's chambers, Minister.
Yeah, go
Yes,
ahead.
good morning, Chair. I was just about to say that Mr. Foreman from the AGC was just like needed. And morning again to you and your colleagues, other members.
Morning, SG. All right, so who's gonna go?
I will go, Chairman, Jeffrey Foreman.
Go ahead, Mr. Foreman.
Thank you. Chairman and members, I think it's appropriate to highlight Section 20 of the Act, which deals with the powers of forfeiture. Forfeiture is the mechanism that allows the state to possess the property of an individual, so that it's no longer that individual's property, but the property of the state, and then the state determines what to do with that property. Section 20 says in subsection 1, where any computer material is seized pursuant to Section 19, that's the Section 19, the power to seize pursuant to a warrant. An order under subsection 2 or 4 may be made in respect of the computer material. Now, subsection 2 deals with a situation where there is a court matter before that's in process. So it says, where A, any person is convicted of an offense, and B, the court concerned is satisfied, and then it lists 3 conditions. The court shall, upon the application of the DPP, order the forfeiture of the computer material used in the commission of the offense. So here, it's a clear contemplation that the proceedings are in train. Subsection 3 says, on the application of the DPP before a parish court having jurisdiction in the area where the computer material is seized, or a judge of the Supreme Court in chambers, the court or judge may make an order in accordance with subsection 4, notwithstanding that the conditions mentioned in subsection 2 have not been satisfied. And as I've just said, the conditions in subsection 2 relate to a trial process, okay? So notwithstanding that the conditions mentioned in subsection 2 have not been satisfied. In other words, there hasn't been a trial.
Okay.
Now, subsection 4 says, where an application is made under subsection 3, i.e., in the absence of a court process and a conviction, the court or judge may order the forfeiture of the computer material if the court or judge is satisfied that A, the computer material has been abandoned, or B, the circumstances in which the computer material was seized give reasonable cause to suspect that it was being used or has been used for committing an offense under this act, and it is otherwise just to do so. So in other words, the court or judge is empowered to review the material put before it and make an assessment whether the computer material should be forfeited to the state in the conditions therein specified. And then the remainder, the other provisions of section 20 provide the procedures that the DPP has to follow in order to invoke the section 20 powers. So for the reason of the statements in subsections 3 and 4, this office concluded that the bill the law is now structured, has a mechanism that allows for harmful material, let's say that is, to be taken from whomever it belongs to, handed over to the state, and then the state will determine what to do with it, which may include destruction. It could include other things. So the reason for the response that we gave to MOCA's initial comments was premised on these provisions. And I would just highlight that the last time there was a joint select committee that reviewed the Cybercrimes Act, my research shows that this forfeiture mechanism was put in there, I think on the recommendation of the DPP's office, and also that this framework that I just read bears similarity to what one sees in other legislation, other criminal-related legislation. For example, the trafficking in persons legislation also has provisions for search, seizure, and forfeiture of property. The Terrorism Prevention Act has similar mechanisms, and both of those involve the DPP being the entity entrusted to make the application to the court, and the court being empowered to make those orders. So I'd like to bring that to the committee's attention. Thank you.
Thank you, Mr. Foreman. Members?
If I may be allowed to pose a question, Chairman.
Sure.
For clarity, Mr. Foreman, are you saying that in the absence of a matter before the court, an application can be brought by law enforcement seeking the forfeiture of computer material with the objective of permanently deleting it?
The process in section 20 entrusts the DPP with the power to make the application. So I would think that the law enforcement officials who coordinate with the DPP a lot in these matters would say to the DPP, we have this material. We think an application should be made to the court, because we're not going to be able to have a charge somebody in relation to this particular material, and then the DPP would be the one under the construct as now provided to make the application to the court under section 20 subsection 3 for the forfeiture process to be put in train.
Might I? Well, thank you, Mr. Foreman, for confirming what I understood you to be saying. Might I then comment to the committee that the category of officers who can make such an application be extended to include the clerks of the court in the context of the workload that the Crown Counsel currently have? I can't speak to how many of these matters may come, but to have them competing with precious judicial and prosecutorial time with more serious offenses, perhaps utilizing the parish court as a forum in which these applications could be made might serve the purposes best.
Can I ask, who has the power to make such applications?
The Director of Public Prosecution, sir.
And
I think that's what Mr. Foreman said.
Yes.
Okay.
But I was submitting to the committee that perhaps an expansion of that category to include clerks of the courts would be useful.
And this is purely now for resource enhancement. In other words, you want an additional scope because of the workload.
Yes, sir. I'm very mindful that this will be competing with more serious matters. And so therefore, if there is a increase in the numbers, as you say, resource enhancement in terms of persons who have the authority to make such an application, then it may better serve the purposes and intention of the legislation.
All right. Thank you, Chair.
So members, I think we have heard the both sides.
You have the AG office with a hand raised and an anxious look.
SG is chiming in. Okay, SG, go ahead.
I would suggest caution with the approach of the expansion, especially because I think you would need to have the DPP weigh in on this. I am aware of there being challenges where clerk of courts make some of these applications and they have to then get the assistance of the DPP's office. I am personally aware of that. So I think before the committee takes a decision, you should really hear from the DPP on this matter. There is a, as Mr. Foreman had indicated, this construct is in several laws. Now, it doesn't mean the construct has to remain the same, but I know that there have been issues with application of the construct when others try to apply it. And it's from that perspective, I am recommending that you hear from the DPP's office. If the DPP's office confirms that they do have these constraints, these HR constraints, then that would be something that the committee should take into account. But I really caution against just listening to a proposal and not speaking to the actual parties that will be affected. Thank you, Chair.
Mr. Chairman, may I say something?
Go ahead.
Yes, I just want to say, before Ms. Aldred spoke, that was in my mind, because I completely understand where MOCA is coming from. And the systems that are in place are sometimes slow, and Mr. Park and his team want to move forward in a faster manner. I think we could, Ms. Aldred's point, though, forces us to be cautious, and I do support the idea of speaking with the DPP and getting their thoughts on it, but I would also like to get the thoughts of the person who is head of the clerks of courts. I don't know what that person is called or who that person is, because I think we should also get their perspective on the matter. And then it be brought back for a decision to be taken.
Noted, Member Rodriguez. I think that if the fact that the SG has come in and made that suggestion, then it would be obviously prudent of us that advice. So what we can do is we can invite a representative from the DPP's office for our next meeting, and then we can take a decision. I'm not sure, SG, can you guide us on the other suggestion by Member Rodriguez about the courts?
As far as I know, the clerk of courts actually report to the parish court judges. And in fact, I know that there is discussion underway for there to be some possible change in that construct where clerk of courts would actually be reporting to the DPP. So if that really happens at the end of the day, I'm not sure that there would even really be a need for the law to mention the clerk of courts if they would eventually be falling under the DPP's office, which is what part of the reason I was suggesting just consulting the DPP who could bring clarity to this issue and explain the process. So I think that's the starting point, the DPP's office.
All right, so we'll take that up. Ms. Brandon, you got that?
Yes, Chairman.
All right, so we get them on and send them the necessary information for that. All right, so we will agree to invite the DPP's office, and then obviously on the conclusion of that, the members will be asked to make a decision in relation to the point that has been raised.
Mr. Chair, just not to belabor the point, but as it stands now, the plan is to have the clerks of court report to DPP, but that's a plan. Not sure when it's going to happen. I would still be curious to know what their thought is on the process, since they're being asked to do this job. And even if they fall under the DPP's office, it's still going to take a time for it to know that it is one of them, since especially there'll be a new set of persons under the DPP office. And we all know how long these establishment processes take. So they report to the judges, but can we get a representative, someone of that group, to speak to us, or at least to speak to the technical team who then relays to us their thoughts on the matter? I still think it is important.
All right, we can pursue that, Ms. Brandon. That's not a problem. We can do some more research and then find the appropriate person.
Thank you.
All right, so that would take care of the matter arising from the last meeting as it relates to MOCA. So in relation to new business.
Chairman, I'm very sorry to interrupt you. We were asked to just give some comments on two proposed offenses that were made in our original submission. They relate to the unauthorized disclosure of a password or access code and unlawful divulging of information. The Legal Reform Department had done some research and provided some comments, and we are guided by them, and we would support the adoption of the provision taken from Mauritius, which gives a construct of the person divulging having to have a knowledge of the disclosure and for it to be done for either an unlawful purpose, for wrongful gain, or knowing that it will cause a prejudice to a person. So we would support that formulation being inserted in the legislation. Thank you.
All right, noted. Is that the only one?
Yes, it is, sir. It is.
All right, thank you very much. Noted.
You're welcome, sir.
All right, Ms. Brandon. In relation to this agenda, I see a discussion on outstanding matters in relation to the provisions of the Act and general comments by stakeholders. Who is taking us through that?
It would be MSET, Chairman.
MSET?
Morning, Chair.
Morning.
Morning, committee members, morning, colleagues. So, Chairman, members, at this point, there is only one remaining matter for consideration that the committee would not have addressed its mind to at all. Of course, with the return of the committee at another point to discuss the matter, which was or further hear from the Office of the DPP in respect of the matter just concluded. The final matter, certainly from this ministry, with respect to stakeholder comments, is in relation to a recommendation that would have been made by UTEC for the inclusion or the establishment of a legislative sandbox for cybersecurity matters. The presentation and discussion around that will be led by Lieutenant Colonel Sterling. And so I'll now yield to Lieutenant Colonel Sterling with respect to that particular recommendation and the consideration.
Good morning, Chair. Morning, members. If it is possible for me to share my screen, I would appreciate that. So apologies for the scroll. The subject that we were looking at was the recommendation by UTEC that a regulatory sandbox be created for the purposes of facilitating things like security research and cyber security activities, including ethical hacking. The scope of what we're going to look at today are some working definitions after a brief refresh of the recommendation that was made by UTEC. The types of sandboxes that exist out there. We're going to then do a bit of a focus on regulatory sandboxes, some of the benefits and risks. We will look at a Jamaican use case, and then we will summarize with our recommendation. So the UTEC recommendation was that there is the consideration given to the granting of exemptions and open license in the context of academic freedom to do cross-border research through the creation of a sandbox that would allow for teaching and learning as well as research and development and other permissible actions. The recommendation went further to look at how this could be implemented in terms of the legislative framework, as well as whether or not there were use cases locally or internationally that could be used, and the use of that controlled environment for things such as ethical hacking. The research to date, for purposes of the discussion, we're including some working definitions here. And the first is regulated entities. And this really is seeking to designate the entities that a regulator has power over in terms of what they do within a particular space. The regulatory sandbox is a contained environment where there are set rules, there are set criteria for participation, there are set parameters for what can be done within the sandbox. And some of them have set timelines within which these activities must be concluded. There are two main types, the regulatory and the industry sandbox. And we will look a little bit closer at each of these. So the regulatory sandbox creates a safe space for the businesses within a sector to operate, but it is really developed by the regulator for that sector, while the industrial sandbox is developed by businesses within the sector and may or may not have the participation of the regulator for the industries or entities within that sector. With respect to the regulatory sandbox, the key objectives here are really to improve products and technologies and to enable the regulator to be in a better position to drive changes and keep the criteria for participation relevant to the industry or sector. There are two main models that are in use across the globe. These are the authorization and the notification models. And we will look at each in turn. So with the authorization model, the benefits are really flexibility. The regulators can create an almost elastic set of criteria that change and adopts and facilitates the inclusion of participation by entities in the sandbox. There are some challenges because sometimes based on how the criteria are developed, different firms require different waivers sometimes because not one size will fit all. And sometimes a firm in a sector really does not meet all the criteria for participation, but the flexibility here is that the regulator can modify and grant waivers to facilitate the inclusion of those who do not meet all the criteria that have been set out. Whereas the notification model is a little bit more rigid and it requires that whomever is participating in the sandbox actually meets the criteria. Whereas the managers of the sandbox can actually grant waivers. These are normally limited in scope, and the interaction within the sandbox is a lot less inclusive when it comes on to looking at the innovators versus the clients and the customers. Some of the potential benefits of sandboxes is that it allows for signaling especially where there are barriers to innovation and barriers to the whole matter of progressing things within a particular sector. It also helps to promote policy objectives and reduce regulatory uncertainty. It improves the capacity of regulators and facilitates the creation or generation of data that will allow for changes to be made. So in terms of signaling, some of the barriers to innovation really, and in this case, we're looking at cybersecurity, where especially we're focusing with respect to the sandbox on ethical hacking, security research, etc. The challenge that we face here, the entities that are doing these research or ethical hacking oftentimes do not feel the need for permission or to operate within the construct of boundaries. However, the sandbox, even if it is designed for cybersecurity, has set rules that must be adhered to. And this can also create some challenges. A cousin to the sandbox is the Innovation Hub, and certainly we have examples of those locally as well as worldwide, but it really, while there may be overlaps, it does not prove itself to be a competitor in terms of facilitating innovation and change. It promotes policy objectives. And so with respect to cybersecurity, this could be used significantly to enhance how we push the public education and awareness campaign around safe practices, etc., particularly with the testing of products. It also ensures that consumers can access the results of some of these tests to be better able or more aware of some of the challenges that the products that they're seeking to access have endured during these tests. Regulatory uncertainty is something that we have a challenge with here in Jamaica. We see the low level of reporting sometimes based on organizational inertia, as well as a trust deficit between government, regulatory facilities and frameworks and the population in general. And so something like a sandbox for cybersecurity could help to bridge the gap where this is concerned. This would also help to improve the capacity of the regulator to better understand how products being put into the market actually stand up to some of the threats that exist within the market in a controlled space, so that by the time it gets to market, there is an understanding of what some of the pitfalls are and whether or not these can be remediated in time for the release of the product. Policy change, it provides, through the results of these tests, the empirical data that is necessary for revising policy and regulations, not unlike what we're doing here with the Cybercrimes Act. And sometimes what we find, however, though, is that most of the regulators, when they run these sandboxes, they tend not to want to offer exemptions or waivers, because then it skews their data and it provides challenges for them to make decisions. The potential risks of implementing sandboxes from a regulatory standpoint, as per the recommendation by UTEC, the uneven playing field, we're talking about, it's really the regulators who choose who gets to play in the sandbox. This is based on the criteria that are selected and the management of it. And even though it is intended sometimes to really sort of give everybody the opportunity to test their products, that concept of the playing field being level is not always the case, because some entities will meet criteria better than others, and some will just simply not be able to meet some of those criteria. And also it creates challenges for the regulator, because their acceptance of an entity into the sandbox is sometimes seen as a stamp of approval with respect to the quality of the product, which does not always get borne out by the results of the testing within the sandbox itself. The reputational risk of both the owner of the product, the testers on the one hand, and the regulator on the other, is something that has to be borne in mind throughout the process of testing the product within the sandbox. Because once you meet the criteria and you put your product in for testing, based on who does the testing and what tools are used, the challenges that come out may be something that can be easily rectified, or it may require that the product goes back into production to fix some of the challenges that have been unearthed. The adoption of risk is something that can become very deregulated within the sandbox, because once persons get into the sandbox with a product and it survives, then oftentimes no further testing is done to bring it to market. And sometimes the challenge is that the tests are so narrow in focus that they do not really bring out all the pitfalls that may be faced by consumers. And so some of the solutions here is really to keep focus on policy objectives and for there to be discipline, transparency, and accountability with respect to the testing and the dissemination of results of those tests. Sometimes there are misaligned expectations, and management of expectations in all facets is something that really creates challenges sometimes. A sandbox is not a panacea, and it really ought not to be seen as such. What it is a framework within which to test products that are either pre-production or production before they're released to the public. As well, sometimes the best results that we've seen through the research globally has come from sandboxes that are complemented by other initiatives within the environment. There are not many repositories of resources with respect to sandboxes. These came about in probably 2013 to 16. And so the research itself is still ongoing. The solution that we're proposing here is that we perform an analysis of what we're looking for in terms of the sandbox and seek to bring complementary measures to support whatever the sandbox is designed to do and how it is managed. Staffing is required at all stages. The setting up of the sandbox itself, the analyzing of the applications, monitoring of what happens within the sandbox, and how the outcomes are used to generate reports and how these reports are actually pushed out. Do we just publish these reports, or are the testers allowed to do that? Is there the sort of cooperation between tester and product owner, as well as the regulator at the end of the day? This affects how personnel is recruited, retained, how resources are put to it by the regulator and or the participants in it. What capacity is there? Is there a time limit for how the participants operate within the box? As well as how does the cost for maintenance get borne out? And this is primarily significant when we think about putting forward a generalized sandbox for use across sectors, as the research has shown that only 2 countries have attempted that in the past with varying results, one in Western Europe, one in Southeast Asia. And in both cases, the end result was that they ended up going back to a specific use case. In the case of South Korea, which got the farthest, they ended up focusing on the financial sector with a fintech sandbox, and they're still trying to implement the other facets of the SATI law, which they try to implement in a sort of multifaceted, broad-based approach to engender innovation within the technology sector. As far as the Jamaican use case, the fintech sandbox operated by the Bank of Jamaica is the best example. It came about as part of the PCSA of 2010. Section 28 requires that the regulatory entity, in this case the BOJ, takes whatever steps are necessary to encourage the secure transactions across the industry, as well as to enforce the laws surrounding secure transactions. The BOJ, in interpreting that section of the law, it decided to implement a fintech sandbox. And the sandbox itself, really, for their research, they looked at 17 jurisdictions and came up with the framework that is currently in play. The objectives and eligibility criteria are quite broad-based and focuses mainly on deposit-taking institutions. The duration and timing for the use of the resources of the sandbox vary from institutions to institution, but they have significant safeguards built into their framework with respect to how banks are able to test products before going to market with them. So what we're seeing here from MSET is that the concept of a sandbox, though novel, is a very good one. The recommendation from UTEC, however, seems to be suggesting a very general sandbox creation, and the 2 examples that we found did not go that route, even though they started out that way. As such, we really are in support of the way in which sandboxes have been implemented across the globe. That is, they're specific, limited in their reach, and they serve a particular purpose. They also are regulated by a specific entity, whichever industry that we've looked at. The establishment is therefore probably best treated with respect to policies within a sector rather than a generalized government approach, and certainly not written into law or a piece of criminal legislation at this point. And the general concept of a sandbox, there is no example out there to really use. So if the GOJ accepts the recommendation, really it's about developing a regulatory framework that is necessary for cybersecurity activities to take place within, to mandate a regulator to oversee the creation of criteria for participation and management of the sandbox, and to designate the regulated entities, whether these are companies providing cybersecurity services, customers, i.e. individuals, bodies, corporate, public, and private, and to see how these entities operate within the sandbox. So that, Chair, members, is really the discourse with respect to sandboxes. The recommendation from UTEC is very general, and while sandboxes provide the scope for innovation and testing of products, pre-production and production before release, a generalized sandbox written into law, there is no supporting evidence throughout the research for that at this time.
Thank you very much, Lieutenant Colonel, for that detailed presentation. Members, any comments, questions, or clarifications?
Chairman, you know, even though UTEC's recommendation was broad-based, and given the series of events that have been taking place in certain sectors now, I really believe it's a good concept. It's a good idea to explore. My concern would be, Lieutenant, you know, the question of enabling resources and who is going to be part of the players within the sandbox. What would be our primary objective? I can see when we're talking about, first of all, the collaboration between firms. But, you know, who are those players going to be? I like the concept of, you know, testing products and testing services, especially. And, you know, this is a situation where all the players are not of the same type. You might have some big players in terms of big firms participating in the sandbox. You might have some small firms. So it's not going to be an even playing field. But I want us to drill down in a thought in terms of what is the primary objective in this case as it relates to this legislation, and what are those positives that it would bring. But certainly a sandbox is it's a good concept. I heard that the BOJ FinTech one has been working very well. I think it's something to explore.
Through you, Chair, to Member Gill, the comments are noted, and they really echo the concerns that we as a technical team have. The creation of such a sandbox is something that certainly in our near future we ought to explore. Right now, though, we don't have a regulatory framework for its creation or an entity designated as a regulator. And that concept of the players in the sandbox, the completion of the National Cybersecurity Risk Assessment, will help to determine the bodies, corporate, public, and private. And that would help to drive the creation of criteria for participation. But at this point in time, all of that is really work in progress.
The other question I'd like to ask is, I mean, who funds the sandbox? Is it the players who participate as part of the collaborative effort, or is it the regulator?
Where it's a regulatory sandbox, usually the regulator through state funding is the primary bearer of the cost. Where it's a business sandbox, the players in the sector normally fund it jointly, usually based on their revenue streams. However, there is no restriction to having a mixed modality towards that funding.
A hybrid format.
Indeed, sir.
Yeah. But certainly, Chairman, I think it's something that we can explore for the near future, especially in this particular environment to which we're operating. Certainly, I can see the financial institutions participating in this in order to, test not only the products, but the protection of service to their customers. So it's, coming out of these deliberations, it can be a recommendation as part of the report that the committee would have, listened to in the first instance, the representation by UTEC and also the presentation made by Lieutenant Sterling this morning.
Through you, Chair, I am in agreement with Senator Gale's comments.
Thank you, Member Longmore. Anybody else? All right. We can take that and move on. CTD, what's next?
Chairman, that's it for us. We have nothing else for the committee's consideration at this time. And it would appear, Chairman, that the only further matter that the committee would be considering would be the matter in respect of the clerk of court recommendation for them to be able to make forfeiture applications.
All right, so that's the only outstanding item that we take at the next.
Chair?
Yeah, go ahead, Member Longmore.
Thank you. I was wondering whether or not we had come, as you can see, I was waiting for us to go back to the minutes with respect to that item that was of discussion regarding the terminology for damage, psychological versus mental. I don't know if we have come to a final conclusion. I think there was still some deliberations being done there. Thank you.
All right, I wasn't there at that last meeting, so I don't know. Remember Green not on? Anybody from the last meeting or CTD? Can you guide us on that?
Mr. Chairman, while CDT confers among themselves before responding, the matter of mental versus psychiatric.
Psychological
was a discussion, and I thought that given that Senator Dr. Longmore is the only psychiatrist amongst us, we really should consider her opinion on the matter where she disagreed, as had I, with the term used. I understand that this is a legal document, but it has to relate to, because if this matter were to go to court, for example, if any matter surrounding that clause were to go to court, the court would ask for technical guidance, which would come from a psychiatrist. As such, we have a psychiatrist here who is saying to us that the phraseology used in the legalese is inaccurate or could be better expressed using X, Y, or Z. And I think we should listen. And if the technical team, I understand, do not want to listen to the psychiatrist, who is also a politician in this instance, they should seek technical advice from an outside psychiatrist. But I do think we have to, in this instance, take the advice as to the medical term and its correctness.
Thank you. Thank you, Senator Campbell Rodriguez.
Chair, if I could just make an intervention in respect of what my colleagues have just said. I apologize. I'm having difficulties with my computer this morning, both my camera and sometimes my mic. So I hope you're hearing me.
as I recall the issue, the technical team response to us was in relation to the how it is defined in the legislation generally, not just in relation to this act. And I definitely understand their difficulty where if we redefine something in one act and we have it defined in others in a different way, that we really do create another problem that is really not minor. It's actually a significant one. I believe the general view is that the principal legislation being the Mental Health Act, I believe it is, needs serious updating, and I believe that is a plan in the works. What the timeline is, I don't know. But even before they respond, I don't know that we can go forward with it. Do I agree with Senator Dr. Longmore on the need to have an accurate definition? I think whatever we do here has to be subject to what is done in the broader context. May it please you.
Noted, Senator Campbell.
Mr. Chairman, just to seek some clarification, because the point just made by Senator Golding Campbell is valid and must be taken into consideration. The current act that we're reviewing on page 28, on page 32, which is section 28, it says the Interception of Communications Act is amended in section 2, and it basically is amending a definition in another act. Is it that we can't do that in this instance because the two acts do not belong in the same ministry? Because if you can do it here for a definition in another act, why can't we do the same in this instance? That I'm seeking advice on.
Can we get a clarification on that? MSET our AG's department. CTD, you can give
Chairman, unfortunately, I don't think I'm in a position to respond to that, so I would yield to the AGC, LRD, or CPC.
SG, can you help us?
Yes, Chair. I was hoping LRD would have jumped in because I think they had been responding on this issue all along. But just to say in terms of process, so what is usually incorporated like in a schedule, consequential amendments, I am not sure that this would have really been considered a true consequential amendment. But the bigger point would be that the Ministry of Health and Wellness that has portfolio responsibility for the Mental Health Act would have to give its approval. So generally the process is that another ministry does not weigh in to the portfolio responsibility of another ministry unless there is some cabinet approval and an agreement between both ministries. I don't know that that exists right now. So the Ministry of Health and Wellness would have to weigh in. I do recall hearing some discussion that there is a review underway. I am not sure where that review is. And again, Ministry of Health and Wellness would have to be the ones to explain all of that because it impacts their portfolio.
Chairman, if I may.
Right.
Okay, so not to belabor the point, I recognize that a lot of why we are in this level of discussion is that there is a lack of understanding fulsomely. If you reflect on the minutes, you will see where I tried in the last meeting to explain at great lengths the point that I'm trying to get across, with reference to the Mental Health Act, there is no reference to psychological injury per se. In their definition of a illness, it is basically diagnosed and reflected as a mental disorder. So if we are to try to align even this terminology being used in this act, it would be best for us to go with the mental reflection rather than just the limited psychological. As I said, I think there's also an advantage in the terms that we would be somewhat up to date with the Cybercrimes Act, which is a technologically more advanced act than most of the pieces of legislations than we're looking for. So us including an expanded terminology, I think would bode well for the foresight of the act and would also propel the impetus for us to bring the review to the Mental Health Act that is greatly needed. So I'm just, in summary, just saying that I will adamantly stick to my point that we are being limited in the reflection that we have here, that if we are to keep it in keeping with the Mental Health Act, it is referred to there as a mental disorder, not psychological injury. And so psychological injury being used in this term would be limiting. And I significantly would recommend, again, that we make the adjustments necessary. Thank you, Chair.
Thank you, member. All right, so at this point, can we go back to the confirmation of the minutes for the meeting held November 24th, 2022?
Chairman, before you go, what's the decision of the committee regarding the issue of mental injury versus psychological injury?
Based on the proposal from member Longmore, I haven't heard anyone in disagreement with that. Can the members confirm for me?
Mr. Chairman, as I'd said, I was the one who raised it, and Senator Longmore was the technical, giving technical advice. From what I'm hearing, the team, and then what Senator Golding Campbell has said today, it has added a new dimension to it that I never thought of, which is important. The question I asked about why could we have done it in the current act for the Interception of Communications Act, and the response is because it's different ministries. Personally, Mr. Chairman, I believe we need to do things correctly. And while it is expected that the Mental Health Act will be under review, it could be now, it could be 10 years, it could be 5 years. I think it is important that this ministry reaches out to that ministry and see if this can just be sorted. We can just do what was done here, if they agree, and we amend the definition through this act the way we did before, because that seems possible based on the response that was given. So I just think we should do it right. And this is cybercrimes, which means we're more forward thinking in this bill than a lot of others. So to put back the same thing that is incorrect, I'm not comfortable with it, Mr. Chairman.
So you're suggesting that we have dialogue with MOH and see if we can come to an agreement?
Yes, Mr. Chairman.
We would have come to agreement with agencies who are participatory to this legislation, So it takes nothing from a concern being raised for one ministry to be talking to the other ministry, explaining the urgency that is required, if they so accept and find merit with the submission that has been made. So I think it just needs a ministry talking to the other and finding a common ground of conclusion.
All right.
Chair, if I might,
go ahead.
Judith Grant, Chief Parliamentary Counsel. Just to point out, though, I think the way these matters had been dealt with in terms of things that cut across portfolios is that the committee would make a recommendation. I think this amendment to the Mental Health Act would be beyond the remit of this committee, which is to review the cybercrimes bill. So in keeping with how other matters similarly have been treated, where we are dealing with other legislation, is that the committee would make a recommendation.
But the understanding, Ms. Grant,
in this. Sorry?
So just a correction here. My understanding is that it's more than a recommendation, and I refer you again to page 32 of the current.
Yes.
So
I
it's
was
it's a recommendation, but what the person before you mentioned was that it would require them agreeing. So we don't want to just make a recommendation, we want them to agree. So are you disagreeing with your colleague and saying that's not how it's done?
And not disagreeing with my colleague. I'm agreeing with the point that, yes, it's a different ministry and so they would need to agree. But I'm pointing out that given the remit of this committee and the way other matters that are treated with that required amendment to other legislation that are not consequential, is that the committee would make a recommendation that the other ministry consider amending its legislation in line with what was proposed. Also, on the point of the amendment that was made to the Interception of Communications Act, that could be considered to be consequential because that was a parallel regime dealing with the investigatory power having to do with the handing over of the key. So in that regard, to sync the two regimes, that amendment was necessary and consequential, but I'm not sure that the same could be said in relation to the Mental Health Act. That's my point.
I think it's consequential if it's going to hook on the matter of whether or not it's consequential. I'm not trained in psychiatry or mental health, but I think it is consequential and should be considered as such.
Chairman?
Go ahead, member.
Yeah, so as I said, don't want to belabor the point. I just wanted to make one quick correction that it was I who had raised the point from the very early days of our sit-ins. I think probably from about the second sit-in. And from back then, there has been this kind of deliberation. And to be honest with you, I'm a little bit disappointed that at this stage, we still have not consulted with the relevant ministry to get the clarification that is needed, especially when I, as a member in my capacity, has been raising this point intermittently for so long. So I also cannot understand why there is such a resistance to an amendment that or a change that would be all encompassing and would not exclude the provisions that currently exist and the operations of the jurisdictions as they are now. So, you know, I like I said, I don't want to belabor the point, but I think that especially for the Cybercrimes Act, we should be as advanced and reflective of the foresight that might be necessary in its execution. Thank you, Chair. That will be my last comment. Thank you.
May I make a suggestion? Because this is on a process. A very important point has been made in relation to finding an appropriate definition to encompass in this legislation. I made the point in November that it should be part of our report to the Parliament, but it does not stop us from having dialogue with that other ministry. And certainly when the proposed bill goes to Parliament, it will have at least 2 bites of the cherries, one in your house and in ours. And maybe by that time, we can come up with a clearer understanding, hopefully. So let us just run it through. We would make the recommendation. We have the authority as a committee to make such recommendation. And if they find acceptance to it, then we can have an understanding. Let's just take it through the process.
So with that said, I take it that the way forward is for for MSET to be in touch with MOH and put the position of the committee to
Right.
MOH and ask
Right.
them
And we would put our position in writing as part of our report. So it's not lost.
But also, Mr. Chairman, as Ms. Grant just pointed out, the same section 28 that I keep referencing happened because it was considered consequential, where an amendment was made in another piece of law through the Cybercrimes Act. If we can have the Ministry of Health agreeing for that amendment to be made in the same manner, because I think my colleagues and I are saying we think it is consequential enough. That is what we want them to ask the Ministry of Health, not just give a recommendation.
Noted, Member Campbell. CTD, you got that?
Minister, our undertaking would be, and I'm hearing the conversation to be suggesting this, that the report of the committee would make a recommendation in respect of how this matter is to be treated with, that is how the term damage is to be defined and what terminology to be utilized in that regard. While that is happening, the ministry will engage the Ministry of Health on the matter of the definition of damage broadly, or mental injury, mental or physical injury, bearing in mind the opinion of the LRD. So all of that will be brought to their attention as a parallel activity. I would anticipate that as the report is tabled of the committee, is tabled in both houses for consideration, the work of the ministry would still need to continue, because I would remind the committee that it's not now considering a bill, it is considering an existing piece of legislation, and what will have to happen subsequent to the consideration of the report by Parliament is that the ministry would then have to engage the legislative process of preparing cabinet submission with respect to amending the legislation and then issuing drafting instructions to the CPC for the bill to be drafted and then returned to the Parliament. And so that would be the process. And in that process as well, the engagement with all the relevant stakeholders will again happen. But it is a parallel process. We will commence the dialogue with the Ministry of Health and Wellness with respect to and share the minutes if required, and the thinking of the committee in respect of this particular matter. And we will be guided by the Ministry of Health in respect of what it is that they would determine suitable in the circumstances. And I don't think it is for this ministry to insist on a particular course of action, particularly with respect to a matter that falls outside of our scope, but we will certainly dialogue with the ministry on this matter.
You have it right in terms of the parallel CTD Murray. What I would want to ensure, however, is that there is some agreement coming from this committee in terms of what we're putting forward as a possible definition. If we are not grounded in accepting what that definition would be, it would be difficult for us to even get that other ministry to be in agreement with us. So we would have to be grounded as to what is it that we are recommending as a definition for them to for us to get acceptance.
So CTD, the point I think member is making is that the committee's recommendation has to be strong, and it has to be communicated through the ministry in relation to what our position is.
And maybe if you'll indulge me a little, Chairman, committee members, maybe we could ask the LRD to just refresh the committee on what the consideration was for this particular matter, and then a decision can be taken by the committee as to what language it is that it will be proposing in respect of the definition. I think maybe that would be an appropriate course of action.
So I guess we'd have to wait on that draft then.
I'll yield to Ms. Simon, who is from the LRD on this particular matter, because if I'm not mistaken, she would have reverted to the committee with respect to, on the last occasion, with respect to a definition. So if she's minded to treat with that now, or then.
Ms. Murray, do you happen to have a copy of the draft? I'm not finding one on my computer at the moment. I'm trying to find it, but I was looking for it while you were speaking. I'm not locating it on this computer at the moment.
One moment. Chairman, not to detain the meeting, but might I suggest the committee take the minutes of the meeting just while I try to locate this document so that.
Sure, thank you.
Dead space.
Sure. Member Gill, the minutes, confirmation of the minutes.
I have no difficulty with the minutes, I can confirm.
Seconded.
Seconded, Member Longmore. Any matters arising from the minutes anybody wants to raise?
The one that we're dealing with now.
We're discussing such now, sir.
Any others? All right. Can the members check for me to see whether Wednesday, March 22nd at 10 a.m. is good? That's what Ms. Brandon has gotten for us in terms of time slots for committees.
On my side.
Wednesday, March 22nd at 10 a.m. All right, so we can take it that we can set that meeting for Wednesday, March 22nd, at which time we're going to have someone hopefully from the DPP to weigh in on that matter that was raised earlier with a presentation by Mr. Park from MOCA. And then, of course, we would want to know at that point, hopefully be able to start looking at the draft report and the list of amendments. All right, CTD, we're waiting on you whenever you can find that document.
Chairman, I'm having a challenge actually placing my finger on that particular document, and I'm going to primarily because of our issues last year, latter part of last year with our emails. as you would recall. But if Ms. Brandon, would you be able to assist? Because I'm absolutely sure that this document was shared with the committee members by email. I'm not sure if you would be able or in a position to just put your hand on it a little bit more quickly than I'm able to. It's the title of the document would have been Summary of Position. Thank you so much. No, not that one. It wasn't from, it was another document directly from the LRD with a summary of the position on the definition of damage.
I would need a few minutes to locate the document.
Right, so the title is Summary of Position, mean mental or psychological injury. That would have been the title of the document. I am confident that it was shared. Unfortunately, I can't access it from the email.
If it assists, I think the title of the document under which it was emailed was LRD Advice on Sections 2 and 9 of the Cybercrimes Act.
What I'm finding is the document from 2015 when it was first raised, actually. I'm not finding the other one.
Chairman, I believe, committee members, I believe I found it. So give me one moment to share my screen.
Is this the document you're making reference to, Ms. Murray?
Yeah, was that it? You had one.
This is the one you're referring to, Mr.
Of the section, is that the one?
Or is it the other one with respect to the summary of the background issues to be clarified, summary of the findings and so on, which would include the redrafted. Ms. Randon, if you could maybe stop sharing and I'll share the one that I found. Thank you. Can members confirm that they're seeing my screen? this one.
Mhm.
I'll scroll. I'll go ahead as you wish now. So.
Oh, you mean me, Miss Murray? You were speaking to me?
Yes, I was yielding to you because I know you would have prepared this document and be able to walk the committee through what was previously considered and the proposal in respect of the consideration. Because my understanding from Member Gale is that the committee should be in a position to indicate what its recommendation is in respect of the term.
Okay, so
Guided by the legal team, of course.
Absolutely.
okay, so as you'll see on the screen, we had received recommendations from UTEC and PSOJ about the definition of damage, and that had included the suggestion to include psychological injury by UTEC and mental injury or psychological injury by PSOJ. So we had conducted research into looking into how these terms were used in other jurisdictions in legislation and how they were interpreted. And from the summary of our findings, we found that only one jurisdiction used mental injury, and it was defined as a clinically significant behavioral, cognitive, or psychological function. And from case law, it was considered as a disturbance of the mind that is serious and prolonged and rises above ordinary annoyances, anxieties, and fears that come with living in civil society and need not be proved by medical evidence. We also found that where mental harm was used as opposed to mental injury as an ingredient of the offense, the courts adopted the civil standard and required that the victim must suffer from a recognized psychiatric illness. And we found that the courts applied a different standard when they were looking at psychological injury or harm. And usually psychological injury or harm is considered as an aggravating factor in determining the appropriate custodial sentence, not as an element of the offense. So based on the research, even though we are understanding the concerns about the narrowness of psychological injury, we had proposed using psychological injury as opposed to mental injury. Our concern being that mental injury required a higher threshold of proof that would not be met in the ordinary case where somebody suffers some kind of injury as a result of something being published online as a result of a cybercrime. And we thought that it would be more prudent to use psychological injury for that reason, because we think that in the usual case, the person would not satisfy that higher threshold. So in trying to cover the issue more broadly, you could actually end up, we think, harming the victim of the offense, because they then now have to satisfy this higher threshold, which may not be met in the ordinary. So that was our concern, which is why we favored psychological injury. An alternative we had also put forward was that the definition of damage in Section 2 could be adjusted to refer to causing or threatening bodily harm, as opposed to using either one of the terms. And then it would be up to the court in considering whether or not what the person has described in putting forward their case, their experience, to determine whether or not that injury, psychological or mental, amounts to bodily harm, as opposed to fitting the experience under one of those heads. If you use that broader term, bodily harm, it would cover both of those scenarios without us having to worry about the term worry about using a term that could work out to the detriment of someone else. We were suggesting using that broader term, bodily harm. And the third option we had recommended was that there be broader consultation because of the implications we saw for the chart based on the term used, because of the different implications that we found in the research. We were suggesting broader consultation amongst medical, legal, judicial, and academic experts to resolve the issue as to the type of injury that would be appropriate for inclusion in the legislation.
Chairman?
And Ms. Murray was just scrolling and showing what we have been proposing the revised section 9 would have looked like, which would have referred in our redraft to psychological injury, not mental injury. We proposed using this as opposed to what is there now, because the definition of how section 9 is set out at the moment, it requires proof of some issues like that the material is obscene and a number of things that the DPP found challenging to meet because it's a conjunctive provision and you need to satisfy a number of things which are not always met in each case. So we had proposed this redraft, which we thought would cover a lot of the different types of harassment and bullying and issues that people suffer when people post information online, when they disseminate information via social media, WhatsApp, whatever. We thought that this redraft would better capture those situations, revenge porn, all of those things, rather than the existing section 9.
Member Langmore, you want to come in?
Yes, thank you. If we could scroll up to the beginning of the document, please, where I think, okay, down, sorry, down. Okay, stop. It is called, just go down one little bit, please. Yes, okay, stop. All right, so at the last bullet points, courts apply a different standard where infliction or cause of psychological injury or harm is considered. And basically, using psychological injury is considered an aggravating factor in determining the appropriate custodial sentence, not as an element of the offense. That exactly speaks to the significance of my point. We have to recognize and reflect that an issue or an injury that can affect us mentally can in and of itself stand as an offense. And what is reflected here, and I think that there is some level of still a lack of understanding as to the scope of psychology versus mental. Mental encompasses psychology, and it encompasses psychological. Psychological can exclude the full mental capacity. And what I'm trying to get across, and I know that we are going over this repeatedly, but that essence there of it not being an element of the offense, we should see the psychological or the mental injury as an offense in and of itself, as an offense that it does not have to be a part of the consideration for other injury. And this also adds to the point and the importance of this piece of legislation setting the standard, so to speak, of the possibilities of the level of injury that could happen in a virtual experience. And so I think that actually even makes my point even more. And I think that I will yield to the committee's decision. And as Senator Gale indicated, we will have other forum where we can raise the point again. But I'm even more firm in my conviction that it should reflect mental injury. Thank you, Chairman.
Thank you, member, for that. So again, we will take it that we will follow what was said earlier in relation to the contact with the MOH and to make our report reflect the position that Senator Longmore has just reiterated.
And Chairman, option 3 gives an opportunity to have some further consultation, says the medical, legal, and judicial. Because everybody, you know, at the end of the day, everybody has to be on the same page for it to be effective and meeting the needs and the requirements of the legislation. So we can still use the time to have some consultation to come up with the best possible definition. And I'm suggesting that we use the opportunity of option 3 to explore such objective.
Noted, Member Gill.
Thank you, sir.
I don't think anybody has any objection to that.
None, sir.
We're clear CTD on the way forward in relation to this matter. Yes,
Chairman,
Brandon?
I'm clear on the direction that the committee is. So I would just confirm that Ms. Brandon is clear what it is that the report should be articulating, and my understanding is that the consideration of the committee on this particular matter will be summarized in the report and reflected, and the option that will be, well, the recommendation of the committee will be reflected as being option 3. That is my takeaway, Chairman and members.
Member Gill, you okay with that?
Yes, sir.
All right, so can I confirm again that the next meeting will be Wednesday, March 22nd, 2023 at 10 a.m. And at that point, Ms. Brandon, you're going to be in touch with the Office of Director, Public Prosecutions.
Yes, Chair.
And then from there, we'll go to the next step, which would be obviously the draft report and the list of suggested amendments.
Yes, Chairman.
All right, members. On that note, we're just 11:47, so we're just off of the midday target. So we will adjourn until Wednesday, March 22nd at 10 a.m. Thanks for those who participated, MOCA. And we see you on the 22nd of March. Until then, keep safe.
You too, Chairman.
February is Reggae Month. Go catch the rhythm on Reggae Month TV, 8 p.m. to 11 p.m. daily in February. Catch the mega reggae concerts, interesting reggae documentaries and symposia, reggae conversation